Right, where are we now? Alternate dispute resolution. Now, a person who seeks a legal relief must consider all options which are available to him or her to resolve the dispute. Not every dispute must be resolved through a process of litigation. There are other means available to resolve matters amicably out of court. An out-of-court settlement may be beneficial than a litigation process for the client, where, for example, the financial expenses which may be incurred from litigation is proportionately higher than the amount of claim which he or she may get from litigating the dispute, or where the dispute lacks merits, or it is in the best interest that the parties' relationships are preserved. It is possible that they may be in a profitable business relationship, or simply the party may not wish to go through the anxiety which follows a court proceeding, or the adverse publication which may be generated from losing the case at trial. And so, parties may want to look at other options that are available to them besides litigation. Now let's take a closer look at alternate dispute resolution. Now, although litigation in court has been the established method to resolve dispute for centuries and is still continuing, there are other forms of dispute resolutions which has emerged as a viable means of resolving conflict between parties. The trend is to employ ADR, or alternate dispute resolution process, stems from the assumption that ADR will address issues of financial costs in the litigation processes, delay, and the complexities in trial. In Australia, alternate dispute resolution has become an integral part of the formal justice system. The states and the federal government in Australia have statutory provisions for judicial referral of matters to ADR processes. The courts have been given power to make a broad range of referral orders, and this includes referrals to ADR. In certain matters, however, it is a precondition that the disputes are referred to ADR. They include the Commonwealth Native Title Act 1993, the New South Wales Retail Lease Act 1994, the New South Wales Farm Debt Mediation 1994, the Commonwealth Family Law Act 1975, and the Family Law Act 1975, Section 601. Right? They are organizations either wholly or partially funded by the state, community mediation or dispute resolution services, such as the Community Justice Centres of New South Wales, designated to resolve disputes. They are also the Family Law Dispute Resolution Centres for family disputes. Now, ADR has also been used widely outside the legal system in matters involving disputes in governments, organizations, schools, communities, and more. They are private organizations recognized by the state, but not necessarily created or funded by the state, that provide appropriate dispute resolution services. For example, the Industry Ombudsman Scheme empowered to resolve many consumer issues, such as the New South Wales Ombudsman or the Energy and Water Ombudsman. The aim of referring cases to ADR is essentially to facilitate early resolution of disputes. Numerous forms of ADR may be employed. However, the most commonly used include negotiations, mediations, and arbitrations. These will be looked at shortly. Before that, we will look at some of the key features of ADR processes and the roles of parties in the particular ADR. The particular ADR may be either advisory, facilitative, or determinative of dispute in nature. In adversary processes, the parties present their arguments to a neutral third party who then uses his skills and knowledge of relevant laws to arrive at a non-binding decision. The parties then embark on either further negotiations or decide to proceed to litigation. In a facilitative process, like in advisory, the parties present their case to a third person. However, here the third person will employ his skill and knowledge to facilitate the parties in arriving at a settlement of dispute. Any resolution is achieved by parties themselves, and the third person only provides assistance to parties to reach an agreement. A determinative of dispute has common features of traditional form of litigation process. In determinative, the parties present the arguments to a third party, who then determines the disputes and make a binding decision. It often incorporates some law of evidence when deciding issues. Unlike adversary and facilitative, parties with viable commercial relationship which they may wish to continue may be lost in this type of dispute resolution. Now let's look at the various types of ADR processes. Of the many that will be looked at, mediation and arbitration will be covered in greater length. Now, the first type of ADR process that we will look at is negotiation. Negotiation is one of the most informal form of resolving disputes. Lawyers are often expected to negotiate on behalf of their client. It is only when negotiation fails that the matter will be litigated. Litigation is ordinarily conducted without prejudice. In other words, the communication between the parties for the purposes of settlement may not be admitted in court unless the said privilege is withdrawn. Expert determination. Parties present their arguments and evidence to an expert, and an expert makes a binding determination of the disputed facts. The expert is chosen based on his expertise in the subject matter. His role often includes investigation and inquiry to ascertain necessary information. Next, early neutral evaluation. Parties, could be their lawyers as well, present arguments and evidence to a private third party, usually a retired judge, who makes an evaluation. He or she will evaluate based on what, in their opinion, would be the likely decision if the matter went on for hearing. Mediation. Mediation is a facilitative negotiation involving a mediator facilitating the parties in identifying the issues in dispute, encouraging them to communicate, negotiate, and consider options, and finally reach an amicable settlement. Now, mediation has been broadly defined as a process in which the parties to a dispute, with the assistance of a neutral third party, known as the mediator, identify the disputed issues, develop options, consider alternatives, and endeavor to reach an agreement. It is often viewed as a structured negotiation process in which the mediator, a neutral and independent party, assists the parties to a dispute to achieve their own resolution of disputes in the Now, what a mediator does is he guides the parties through various stages in a meeting. The stages in brief include the following. Firstly, the mediator introduces himself, explains the objectives of the mediation, the nature and the purpose of the meeting, clarifies his role, and explains that matters discussed will be subject to confidentiality rule, and verify that parties have understood the nature of mediation. Secondly, the parties then state their own perspective of the dispute, makes a presentation explaining and highlighting their interests and needs and claims. Thirdly, mediator identifies and clarifies issue and focus on matter of contention in consultation with parties. Fourthly, mediator will explore and examine options, discusses as many options as possible with the parties, and propose potential solutions. Fifthly, if the parties agree to the solution proposed, then the matter will be resolved in a manner which is satisfactory to all. Sixth, the mediator will draw up an agreement, verify it, and have the party sign the agreement. And lastly, he will submit a closing statement, and that's the end of mediation. Now, it can be seen from the description above that the mediator essentially have limited determinative role. He or she may determine how the process will be conducted. The mediator will look for common grounds in the dispute to encourage settlement. He or she, however, could not determine the outcome of the dispute. Now, it is important to understand the characteristics of mediation in order to appreciate how it operates. There are 4 essential characteristics discussed by Noon in his article, Mediation Essential Legal Skills Series, Cavendish Publishing Limited. It might be worth looking at the article for a deeper understanding about mediation. I shall, however, highlight some of the key characteristics discussed in the article in this lecture. Now, we have looked at the first characteristics, the facilitative characteristic. Essentially, a mediator facilitates the parties to reach an amicable settlement. The second feature identified is accessibility. By this, it means that mediation is accessible to parties with any type of disputes. It may be resorted to at any stage, before or during trial of the case, and even after the verdict, if there's a possibility of appeal. Now, the third characteristic is that it is voluntary. Parties make a decision whether to have their dispute resolved by a mediator of their choice. Essentially, parties are in control of who is selected to participate as their mediator, the terms to which they